When I was in law school, I was very much the typical idealist who went into law school with high hopes of graduating and then changing the world with the law. At the end of my degree, however, I was a tired, grumpy, skeptical, sarcastic, jaded, and slightly angry millennial mess who for sure learned a lot about the law, but had to also ultimately accept that no one is really fully equal in the eyes of the law. Also, I graduated right after a global financial crisis, and that certainly did not help the mood. But despite my newly won jadedness, my fellow law students and I understood clearly that even in the most functional of democracies, one thing stays true. If one has either power, wealth, connections, or high social standing, or all of the above, one can usually, not always, but usually bypass the law on some level or the other. And these were my thoughts exactly when researching today's case. The stories I've told you here on this podcast so far elicit feelings of frustration because we either do not know who committed the crime or why a crime was committed, or we know the police missed an opportunity to properly investigate a case, or we have judges who seem to not know what they are doing. But in this case, the system seemed to have worked quite well until it did not. This is the story of the Maureen Hultman and Ronald Chapman double murder. Mabuhay. Welcome to another episode of Lagim, a Filipino true crime podcast. I am your host, Christine, and I am glad you could drop by and listen to today's episode. Make sure to listen until the very end of this episode for a very short case update on one of our previous episodes. Please note that details in this story can be upsetting and disturbing to some people, so please take care of yourself whilst listening. Like a lot of teenagers her age, Swedish Filipina Maureen Holtman explored life with zest and excited vigor. She was 16 years old, beautiful, and thriving. She had been approached for a model job and had just received her first ever paycheck from that very same job. Life was good. And like a lot of teenagers as well, Maureen liked to bond and hang out with friends on a weekend. And this was not any different when Maureen went out on the 12th of July, 1991. The events that took place afterwards were recounted and recorded in a Supreme Court document and YouTube video clips, which I have, as always, linked in Lagim's sources list. According to the court documents available and reports from the time, Maureen was invited to a friend's place in Forbes Park, Makati. The friend in question was Jussi Olavi Leno, who told Maureen and other friends that his party would be starting at 8:30 in the evening. The youngsters partied at Jussi's until around midnight, and then they proceeded to a pub called Roxy's, where students of the international school usually spent a lot of time in. After about an hour, they then transferred to Vintage, another pub in Makati, where they stayed until past 3 in the morning of July 13th, 1991. Their group then returned to Roxy's pub to pick up another friend, and then they all headed back to Jussie's to grab a bite to eat. After hanging out for a while, Maureen decided that it was time to go home. She asked Jussie if he could possibly drive her to her upscale neighborhood of Dasmariñas Village in Makati. He said yes and started to gather his things. Another friend of theirs, Ronald Chapman, decided to tag along. It was about 4 in the morning when the three friends finally made it to the village. Maureen asked Jussie if he could drop her off, not directly at her home, but just nearby on Mahogany Street, so as to avoid waking up her parents. Jussie did just that and then offered to walk Maureen home just to be safe and sure. The two friends then started walking whilst Ronald Chapman stayed in the car. Whilst walking, and when they were nearing the corner of Mahogany and Caballero streets, Maureen and Jussie were startled by a light colored Mitsubishi box type Lancer car abruptly stopping near them and in the middle of the road. They looked around to see what was going on and who was driving the car. They saw a man get out. The man approached Maureen and Jussie and asked Jussie who he was and to show him his ID. Jussie was under the impression that this was someone official, perhaps from the police, wanting to confirm his identity. So Jussie pulled out his Asian Development Bank ID to show to this man in front of them. Jussie, who is a bank executive, would later recall how the man did not really bother to check his ID, but instead proceeded to grab Jussie's wallet and slid it into his own back pocket. I would assume at this point both Maureen and Jussie sensed that something was not right with this man and that he could not be from the police at all. Ronald Chapman, who was observing this scene unfold from the car, most definitely sensed that his friends were in a bizarre and possibly unsafe situation. He got out of the car and approached the group, asking the stranger why he was bothering his friends. From this moment on, the situation quickly escalated. The man pushed Ronald away, reached into his shirt, and pulled out a gun. He pointed the gun at Ronald's chest and fired at him. The three youngsters were shocked. Ronald staggered for a few moments before collapsing onto the street, but before he did, he managed to ask the stranger why he had shot him. Jussie rushed to Ronald's side to check on him, but the shooter shouted at Jussie about leaving Ronald alone. Jussie would later recount how the shooter then turned towards him and asked him if he wanted trouble as well. Jussie, of course, said no. Meanwhile, Maureen, who was still in shock from what just happened to Ronald, finally realized the gravity of their situation and started shouting for help. Jussie would later explain that this angered the shooter, prompting him to point the gun at him and Maureen back and forth, telling Maureen to shut up. The shooter then ordered Jussie to sit down on the pavement, and Jussie had no plans disobeying the shooter with his gun pointed at him. Jussie had thought of running from the scene, but he knew that even if he was able to take off quick enough, the shooter would still be able to shoot at him from a certain distance. So Jussie stayed put, but was now worried about Maureen, who was, understandably, still upset and hysterical. Maureen, who was still standing up, strayed to the side of the shooter's car. The shooter tried to grab her, but failed. Maureen then circled around the car, hoping to put some distance between herself and the shooter proceeded to chase her around the car for about 2 minutes. To Maureen's shock, the shooter was able to grab her, and he seemed angrier now. He told her to shut up and sit down beside Jussie. Jussie and Maureen were not sure what was coming next or whether anyone had heard Maureen's cries for help. They watched the shooter, who was standing around 2 meters away from them. He watched them and then turned his back on them for a quick moment before facing them again. When he did so, he suddenly shot Jussie, who was hit on his upper jaw and who fell backwards onto the pavement. Jussie would later state that despite his injuries, he did not lose consciousness and was therefore able to see, hear, and remember the events after he was shot as well. Jussie would add later in his testimony that he heard another shot whilst he lay bleeding on the pavement. He then saw and heard Maureen fall beside him. Jussie wanted to see where the shooter was and what he was doing in the midst of this chaos of a situation. He remembered that the shooter hurriedly returned to his car and sped away from the scene. Jussie then tried his hardest to shout for help and get back on his knees. Little did he know that people in the neighborhood indeed already heard the commotion outside their homes from the very first shot. It is not known whether any of these neighbors had called the police as soon as they had noticed that something was seriously wrong in the neighborhood, but what we do know is that three people in that area had seen everything after the first shot rang out. The three witnesses were Domingo Florese, Vicente Mangubat, and Agripino Cadenas, who worked either as drivers or as private security for some of the homeowners in that part of the neighborhood. All three men were prompted by the first shot to look outside, and each of them saw Ronald Chapman sprawled on the street and Jussie Leno sitting on the pavement. They saw a third man, the shooter, standing up and waving a gun. Later on, they would recount how they saw Maureen, how they witnessed Jussie and Maureen being shot, and how the shooter left in his car in a hurry. Florese would later explain that he could not see the shooter's face properly as he was too far away. He did manage to note down the second half of the car's number plate, which was 566. He also gave a brief description of the car model, color, and brand as far as he could tell from the distance where he was located. He said that it was a box type Lancer that looked kind of white to him. The other witness, Cadenas, was able to note down the complete plate number, PDW 566. He would later describe the car as being a silver metallic gray one. Both he and Mangubat were able to see the shooter's face. Mangubat said later on that after the shooter sped away from the crime scene, he ran out to the youngsters. He noticed Florese from his employer's home, and then he saw someone pass by him on a bike. He asked that person to call the neighborhood security officers. Florese would later state that after seeing the commotion at the crime scene and after the shooter had sped away, he ran back into his employer's home and told her what he saw. The employer, Helen Rojas, then headed to the crime scene herself, whilst Florese made sure to write down everything that he saw in his logbook. He also included in his entry the shooter's plate number, or at least part of what he saw. Soon enough, the neighborhood security officers arrived and ensured that Maureen and Jussie were rushed to Makati Medical Center for treatment. It is believed that the security guards had already noticed that Ronald was dead and therefore did not have him rushed to the hospital like the other two. Shortly after this, Makati City Police officers and some agents from the National Bureau of Investigation, or NBI, arrived at the scene. It would come to no one's surprise that the police and the agents were able to move quickly in their initial investigation. After all, the witnesses were alert and smart enough to note down the things they had heard and seen. From the court documents, it seemed to me like the police had only talked to Florese at that point and were therefore only able to note down the second half of the plate control number that Florese had observed, which was 566. We will later find out why Cadenas had not given the information he noted down after the shooting. In any case, after talking to Florese, the police then requested from the Homeowners Association a list of registered vehicles in the village, and they were able to track down two Lancers with a plate control number containing the number 566. These two Lancers were owned by residents by the names of Jose Montaño and Claudio Tehanqui Jr., son of the late Claudio Tehanqui Sr., the 16th Chief Justice of the Supreme Court of the Philippines. So, it was now time to pay Mr. Montaño and Mr. Tehanqui Jr. a visit. The officers from the Makati police force and operatives of the Constabulary Highway Patrol, as well as agents from the NBI, would later testify that they first paid Mr. Montaño a visit to ascertain his whereabouts when the crime took place. Mr. Montaño's Lancer was a white one and therefore sort of matched what Florese told the police. Upon arriving at the residence of the Montaños, they were greeted by Mrs. Montaño, who, upon questioning, denied their family's involvement in any shooting. She also informed the police that this particular car had actually been sold and an employee of the new owners had driven the car to their office. Mrs. Montaño then proceeded to call her husband to inform him about the investigation. She also called the person who was now in possession of the car and asked him to drive the car back to their residence for the police's inspection. Jose Montaño and the business employee named Ben Conti then arrived separately at the Montaño residence, with Conti driving the Lancer. Both men and the car were then brought to the NBI office for questioning. At the NBI office, Montaño explained that on the 12th and 13th of July 1991, the car was at Conti's home. He lived in Cubao and was an operations manager for Saldana Lending Investors, the new owners of the car. Conti then later informed the police that on the morning of the 13th of July, he drove the car to the offices of Saldana Lending Investors. The information given by both men were cross-checked with the information gathered by NBI field agents, and the police provisionally accepted their statements pending the identification of the car by the witnesses from the neighborhood. The police requested that the Lancer be left at the NBI office, to which Conti obliged immediately. The investigation continued the next day, the 14th of July. This time, a team of NBI agents decided that it would be best to go back to Dasmariñas Village in Makati. They talked to Florese and asked him to report to the NBI office the next day for further formal questioning. And then they talked to Cadenas. But for some reason, Cadenas denied having witnessed anything. This reluctance was probably the reason why the police were not able to talk to Cadenas the day before. It is safe to assume that when the police first arrived at the crime scene the day before, Cadenas did not show himself to them to avoid being questioned. And now the NBI were faced with a dilemma, as they know from other witnesses that Cadenas definitely saw something. The NBI decided that the best way to get Cadenas to talk to them was to serve him a subpoena, inviting him to appear at the NBI office for investigation the very next day. Having done that, the NBI then proceeded to their next witness. They talked to a resident who lived near the crime scene. The resident was Armenia Asliami, an Egyptian national who may have seen the shooter's car. Asliami informed the NBI agents that the shooter's car was not white, but actually light gray. When asked if she was willing to make an official statement, Asliami refused as she was afraid. The NBI agents tried to convince her to reconsider her decision and also reassured her that she would be protected. When they could not convince her, they asked someone from the Egyptian embassy to help convince Asliami to cooperate and give a statement. but even that effort failed. So, whilst they did not have Asliani's statement on paper, the detail about the car's color was helpful. The NBI agents at that point realized that they needed Cadenas's statement more than ever. So, as a result of the subpoena that was eventually served to Cadenas, he appeared before the NBI office the next day, the 15th of July. Florese was also there as per the request by the agents from the previous day. Oddly enough, Cadenas continued to feign ignorance. The NBI agents felt strongly about questioning him and getting information from him, as they felt like he knew about details that could help them move the investigation forward, or at least strengthen the suspicion they had started to develop towards another person of interest. But the agents could not get through to him. They then asked their superior to talk to Cadenas. Salvador Ranin, who was the NBI's chief of the Special Operations Group, asked Cadenas what he was so worried about. Cadenas expressed to the agent that he was scared of the shooter, who could potentially go after his family if he cooperated with the police. Ranin reassured Cadenas that this would not happen because the NBI would provide protection for him and his family. Seemingly reassured by this promise, Cadenas finally cooperated the next day and gave the NBI agents all the information he could give. Cadenas described the shooter's car and wrote down for the agents the complete plate number of the Lancer car driven by the shooter, PDW 566. Cadenas was then led to the NBI parking lot where Jose Montaño's car was parked. Chief Ranin asked Cadenas if the car in front of him was the shooter's car. Cadenas said that the shooter's car was of a different color. And so Chief Ranin asked Cadenas to look around the parking lot and see if he could find any car that had a similar color to the shooter's car. Cadenas looked around and pointed to one specific car that was of a light gray color. Of course, this was noted down by the agents. Chief Ranin then asked Cadenas if he felt sure that he could identify the shooter. Cadenas said yes. And with this, Cadenas was led back to the NBI office where he was shown 10 pictures of men from the NBI files. One of the pictures was of Claudio Tejanque Jr., their person of interest, someone that the NBI had come to suspect after they investigated the Montaños, and someone who they felt particularly strongly about after Cadenas finally gave them the complete plate number. Cadenas studied the 10 faces in front of him, and after a brief moment, picked Tihanki's picture. He then gave a full official statement to the NBI. Armed with the evidence they had gathered so far, the NBI was confident that Tihanki was their guy. They now needed to get a search warrant for the car as soon as possible before Tihanki became alerted to the fact that he had now become a person of interest. They needed to get to his car as soon as possible. The NBI applied for a search warrant at the Makati Regional Trial Court, and this was granted pretty much right away in light of the strong initial evidence. The NBI agents then made their way to the Tihanki residence and were greeted by a rather anxious Mrs. Pilar Tihanki, Claudio's mother. The agents were informed by Mrs. Tihanki that Claudio was not in at that time. She then excused herself and called someone on the phone, presumably her son. Whilst she was out of sight, Chief Ranin and the other agents made their way to the family's garage and made sure to secure the car for towing. When Mrs. Tihanki reemerged, she was asked for the car keys, but she told the agents that Claudio had the keys. Chief Ranin asked Mrs. Tihanki to phone Claudio in their presence so he could talk to him. Mrs. Tihanki obliged and got her son on the line. Chief Ranin spoke to Claudio and invited him to the NBI office for questioning. Claudio, according to Ranin, assured him that he would report to the NBI later that day. Seemingly satisfied by this reassurance, Chief Ranin and the other agents left the Tihanki home with Claudio's car. Now, just a little bit of a sidebar here. When I first read about how Claudio Tihanki Jr. was called up on his phone and almost nicely asked and invited to the NBI office, it felt too friendly an exchange between an NBI agent and a person of interest in a rather heinous crime. Maybe this is just me reading into things here, but if a person is suspected of gunning down three people, then as a police agent, I would want to know where you are so I can come and collect you, making sure you're going to the police headquarters or the NBI office and not to the airport and out of the country. But again, I digress. Anyway, back to our case. At around 9 that same evening, a Raul Tihanki arrived at the NBI office. When the agents on site asked him why he was there or who he was, they were told that he was waiting for his brother, Claudio. And sure enough, Claudio arrived at the NBI office escorted by 3 Makati police officers. When he arrived, Claudio informed the NBI agents that before arriving there, he was at the Makati police station where he was also being investigated for the shooting. Specifically, he told the agents that he had given the Makati police force his statement and also had to go through a so-called paraffin test. A paraffin test is a forensic test, a forensic tool, to indicate whether a person has recently fired a gun. In this test, the person's hand is coated in hot paraffin wax, which then cools down and sets and is peeled off and tested for the presence of residue from gunpowder. Now, looking at this is a good thing to know for the NBI because they could most probably call upon the police force in Makati to help out with whatever information they managed to obtain. But at that moment, it was time for Claudio Tihanki Jr. to be questioned. Unfortunately, not a lot of questions were asked that evening because it was already too late, but Tihanki did say that his car at the time of the shooting was no longer functioning, or at least it was pretty banged up, following an accident a few weeks ago. The car, according to him, had been parked at his mother's residence in Dasmariñas Village since then. After a few more questions, the agents decided to pause the questioning for the night and advised Tihanki that the questioning would be resumed the next day. Sure enough, the next day, the 17th of July, Tihanki was questioned about his whereabouts when the shooting was taking place in Dasmariñas Village. Tihanki defensively told the NBI agents that he did not see anything because he was not there. It was now time for the police to confront Tihanki about the evidence they had gathered so far, the evidence that was looking very incriminating for him. At that moment, they did not disclose everything they had on him. Instead, they just told him that they had witnesses that could place him at the crime scene as the shooter. Tihanki became quiet. And he did not say much after that. When the questioning did not go anywhere, the NBI agents decided that it was time to prepare a lineup. Tihanki was joined by 7 other men for this lineup and identification. In the adjoining room, and what Tihanki did not know, Cadenas was called in, and Chief Ranin asked him to identify the shooter from the lineup. Without hesitation, Cadenas pointed at Tihanki. After this, Tihanki was taken to Forbes Park, Makati to be identified by Jussie Leno. On that very day, Jussie had just been discharged from the hospital. Now, this was a bit weird to me. I've never heard of a lineup or a suspect identification being done outside a police station, but apparently, this setup was requested by Justice's parents who were worried about their son. The lineup was outside a vacant house in Forbes Park. Six men, including Tihanki, were presented to Jussie, who remained 5 meters away from where the men were standing. Jussie was also in a car with tinted windows. With Jussie was his father and Chief Ranin and another person who drove them there. Now, bear in mind that Jussie was shot in the jaw, so he could not speak still at this moment. But he took one look at the men and noticed that one of the men was wearing a pair of sunglasses. He wrote down on a piece of paper that he wanted to see that particular man without his sunglasses. The lined up men were herded back into the vacant house. The man with the sunglasses was told to remove them, and afterwards, all of them were presented again to Jussie outside of this vacant house. Jussie quickly identified Tihanki as the person who shot him. Tihanki was also the person with the sunglasses. The agents were satisfied that they could now proceed with charges. So, whilst Jussie was taken back to his home, Tihanki was taken back to the NBI office where he was detained after bail was denied. Specifically, the NBI was preparing cases of murder and double frustrated or attempted murder. Now, remember when I briefly mentioned that the Makati police were also conducting a parallel investigation? This is a brief overview of their initial investigation. So, Vicente Mangubat, the private security guard and one of the three main witnesses, was invited for questioning at the Makati police station on the 16th of July 1991, where his statement was officially taken. At the police station, Mangubat was asked to identify the shooter. This identification process was very odd to me as it was not done in a lineup form. Mangubat was sitting on top of the stairs on the second floor of this police station, and a couple of hours later, a police officer and Tihanki entered the police station and ascended the stairs. They both passed by Mangubat and then walked into an office. The police officer assigned to Mangubat then asked him if the man in civilian clothes, meaning Tihanki, was the shooter. Mangubat was hesitant to comment at first, and then he said that he wanted to see the man again just to be sure. He then told the officer that he was rather nervous and afraid. When Tihanki and the officer assigned to him left the office, Mangubat took another look and later confirmed that yes, Tihanki was indeed the shooter. Now, I say that this method of lineup is problematic and odd because the police were essentially leading the witness. In other countries, the method is called a show up identification and has been disallowed by some courts in some countries. By not presenting other men, aka options, in a lineup, the police were unduly influencing Mangubat, the witness. The suggestive nature of this method, coupled with the witness's nervousness and sometimes unreliable memory, can commonly lead to misidentification. In a lot of cases I have encountered as a law student, show up identifications had led to successful appeals by the defendant slash appellant. We'll see later if this also leads to similar problems in this case. As for Mangubat, 2 days later, the police paid him another visit and wanted to confirm if he was really sure that Tihanki was the shooter. Mangubat said yes, and he was, for that moment at least, left alone whilst the police proceeded with their investigation. However, Mangubat would not be left alone just yet by the NBI. By the 23rd of July, Vicente Mangubat was invited by the National Bureau of Investigation and was asked if he's able to identify the shooter. Again, Mangubat said yes. He was then shown 12 pictures of different men and was asked to identify the shooter from those pictures. Unsurprisingly, Mangubat chose Tihanki's picture. He then gave an official statement to the NBI and was asked to return the next day to make a personal identification. Sure enough, the next day, Vicente Mangubat returned and a lineup was prepared for him. However, this lineup was a little bit more rowdy because the media was invited, and someone from that time described what was happening inside the NBI office as a media circus. Tihanki's lawyers were protesting the media presence at the NBI office. Specifically, they demanded to know why a lineup was even needed at the NBI office, since the case against Tihanki had already been filed and any identification should be done at the court from this moment on. Secondly, Tihanki's lawyers stated that there should not be any media presence during the identification. I must admit that on both points, I would have to agree with Tihanki's lawyers, as much as that pains me. I feel that somewhere in the Philippine criminal procedural law and civil rights law, Tihanki's media loaded NBI identification should not have taken place the way it did. Obviously, then Assistant NBI Director Epimaco Velasco wanted to indict Tihanki in the court of public opinion before any trial could even start. This, I can see, would have been quite prejudicial if the Philippines had a jury system, but since it does not, the only problem would be negative publicity and hate directed at Tihanki and his family. In any case, Tihanki refused to join the lineup when the NBI agents were setting it up. He remained in an office and refused to get up. The NBI agents then had no other choice but to ask the other men of the lineup to join Tihanki and the others in that office. Mangubat was later brought in when the lineup was prepared, and he positively identified Tihanki as the shooter. For all intents and purposes, the NBI declared their investigation as good as finished, and it was now up to the prosecutors to lead the trial against Claudio Tihanki Jr. Now, you are probably wondering why I have not spoken about Maureen yet. We know that Jussie was alive and, well, as well as one could be after sustaining a bullet wound to the jaw. But Maureen was a whole different issue. The attending doctor would later give an account as to what happened to Maureen from the moment she was rushed into the hospital. Dr. Leovigildo Isabella stated that Maureen came in with a bullet wound into the left side of her forehead, just above the eyebrow. Her brain tissues were oozing out of her nostrils from where the bullet had entered. Scans later revealed, unsurprisingly, that Maureen sustained injuries to her brain and skull. According to Dr. Isabella, there were several splintered bullets in her brain, and the major portion of the bullet, after it fragmented, was lodged beneath her right jaw. And so, Maureen was rushed to surgery, and a team of surgeons worked on her tirelessly to remove the bullet fragments in her head, to stop the bleeding, and to remove all damaged tissues. Maureen's brain suffered some swelling that made her condition rather unstable. Doctors on her surgical team also sadly reported that they were not able to patch the undersurface covering of her brain. Although Maureen's vital signs continued to show normally, she remained unconscious. Maureen remained in the ICU, and for the next 2 weeks, we are told by various sources that brain tissues and fluid continued to leak through her nose and through the undersurface covering of her brain. By the end of July, Maureen also had to go through another surgery. Despite the success of this surgery, Maureen still remained unconscious. Dr. Isabel would later explain that despite the decreased trickling down of brain tissues through her nose, Maureen had now developed an infection as well. She developed a brain abscess as a result. A third surgery was therefore necessary to remove this abscess and to help prevent further infection. So, how did this one bullet cause so much damage to Maureen? Another doctor on Maureen's care team explained exactly what happened the moment the bullet entered her body. Dr. Solis explained that Maureen was shot to the left side of her forehead. The entry of the bullet was around 1.5 centimeters above the eyebrow. When the bullet entered her forehead, the bullet fragmented into tiny little pieces, and those then traveled to the right side of her temple. This caused a fracture in her frontal skull bone. The bullet eventually stopped moving and settled behind Maureen's right jaw. Immediately, according to Dr. Solis, Maureen's brain suffered hemorrhagic lesions, which is generally a deeply traumatic injury, to say the least. Dr. Solis also added that Maureen had sustained injuries to her eye sockets and right jaw. Lastly, Maureen's inner nose also sustained injuries that caused swelling. I suppose I don't need to tell you how dire Maureen's condition was. Doctors predicted back then and explained to Maureen's parents that if she survived, she would be in a permanent non responsive state and would need assistance with everything for the rest of her life. She could potentially end up blind, her motor functions would be severely affected, and despite rehabilitation, there was a very small chance that Maureen could return to normal. This must have been a very hard thing to take in and accept for Maureen's parents. Their daughter was just starting out life, just testing out the waters of this world, and must now live a life that would be full of pain. Needless to say, Maureen's parents were at their wits' end. Sadly, Maureen, after 97 days of fighting for her life in the hospital, died on the 17th of October 1991. So, what did this mean for the Tehanki case? Instead of one charge of murder and two frustrated murder charges, Tehanki was then charged with 2 counts of murder and 1 count of frustrated murder. But then again, what did Claudio Tehanki have to say to all these charges? Earlier in this episode, we briefly heard how Tehanki denied being at the crime scene. He would later elaborate to the police, the NBI, and eventually the court that he was at his house in Pasig at the time of the shooting. He said that he slept around 1 in the morning, and by the 13th, he woke up around 8 or 9 o'clock. He added that his two house helpers could attest to his presence at his house on that day. When asked about the victims, whether he knew them, he responded that he did not. He stated that he only learned about them when he read the papers. When asked about the witnesses Cadenas and Mangubat and whether he knew them, he said no. Tihanki was then asked about his car, And indeed, he admitted that he owned a box type silver metallic gray Mitsubishi Lancer with plate number PDW 566. He maintained, however, that the car stopped working properly after an accident in February the same year. He then emphasized that the car had been parked in his mother's garage since May. He had therefore not used the car ever since. One thing he did concede when he was being questioned was that the car, despite its damages, could still be used. Tihanki knew that he needed to provide the NBI agents with an alibi, and so he presented his own son, Claudio Tihanki III, who later testified in court that from May 1989 until February 1991, he was in possession of his father's car, which he used to drive to school and back. I am not sure how Tihanki's legal team thought this could help their client's alibi and case, since the shooting happened in July of 1991. I guess the son was presented to merely provide a timeline as to who was in possession of the car at what point in time. In any case, Claudio III explained that he alone had been using the car up until the day of the accident. I suppose with this statement, Tihanki's legal team simply wanted to emphasize that the car had not been working properly because of this accident that took place in February, and therefore the shooter could not have been their client. He did not have access to the car or chose not to access it despite having the keys. Now, part of Tihanki's defense strategy was to blame Maureen's father, Anders Hultman. Tihanki's legal team presented a witness who apparently heard Maureen screaming that morning on the 13th. She said she heard Maureen screaming, wag daddy, meaning no daddy, no daddy, essentially saying that it was Anders Hultman who shot Maureen and her friends. When the case later landed in court, Anders Hultman was called upon as a hostile witness. This simply means that the witness at trial has a testimony on direct examination that is either openly antagonistic or appears to be contrary to the legal position of the party who called the witness. So, long story short, a hostile witness is someone who you are questioning and you know that they're going to say something that is contrary to the case that you're fighting for. Anders was called upon by the defense, and it was to be expected that he would say something that would not be favorable to the defense for obvious reasons. When asked about Maureen's alleged utterances, Anders said that the defense witnesses or witness who purportedly hurt Maureen must have been mistaken because, firstly, Maureen did not speak Tagalog, and secondly, none of his kids called him daddy, they called him papa. The defense also asked Mr. Holtman about his apparent dislike of the police and of the prison treatment of Tihanki. This was a weird thing to ask since one can surely anticipate how the father of one of the victims felt about how Tihanki had been spending his pre trial incarceration. And if you're now asking how Tihanki had been treated in prison, well, it may come to no surprise to you as well that given Tihanki's background, being the son of a late Supreme Court Chief Justice who swore in late President Corazon Aquino and who also served as an ambassador of the Philippines to the United Nations, Tihanki was not, in Holtman's opinion, treated like a normal prisoner. There were times when Holtman would check on Tihanki in prison because he was allowed to do so by the courts, and he would discover that on a lot of days, Claudio Tihanki Jr. would not even be in his cell. The jail guards had also started covering up for Tihanki's whereabouts whenever he was not in his cell. This raised more than a few eyebrows because it showed yet again that in the Philippines, a lot of times, one's money, status, and connections can essentially get you loads of perks. And this was true of Tihanki as well. This was a mere foreshadowing of what was still to come in this case. The defense then proceeded to cast doubt on the prosecution's case about the other Lancer car. They presented witnesses who essentially implied that it may have been Ben Conti, who worked for Saldana Lending Investors, the new owners of the car, who shot Maureen, Jussie, and Ronald. Of course, we know that this is complete rubbish. Furthermore, the defense made statements about a house helper who apparently heard the commotion just before the shooting. The house helper, who was not presented at court and who did not submit any official or signed statement, apparently told one of the Makati police officers how she also heard a female voice scream, "Daddy, don't shoot, don't." It is not clear from the court documents whether this house helper heard this being screamed in Tagalog or English, but it certainly aligned with one of the witnesses that we've already heard about. However, it is odd to me that the defense never asked the court to have this house helper subpoenaed so she may give her testimony in court. As it stood at that moment, this was just hearsay by the police officer who relayed the house helper's statement to the court. The evidence being hearsay should never have been admitted as evidence in support of the defense. Now, when I looked at how the courts recorded the trial, I certainly got the sense that the defense worked hard for their money. They tried everything to get their client off. They tried to cast doubt on Vicente Mangubat as well. Remember that Mangubat was the witness who, according to the NBI, identified Tihanki at the NBI office during a show up identification. They had other witnesses, aka other police officers, who swore in court that Mangubat could not identify Tihanki as the shooter. Mangubat apparently said that the shooter was a bit younger and had fairer skin. Obviously, Claudio Tihanki Jr. was already 50 years old at that point and was not necessarily light skinned. Furthermore, the defense also presented another lawyer who worked with Tihanki and who talked to Cadenas' boss at the security agency. Remember that Cadenas was the other witness who was able to note down the complete car plate number. This lawyer, attorney Manuel Malvar, stated that Cadenas' employer allegedly admitted to him that the only reason Cadenas gave a statement to the NBI was because he was tortured and forced to make a statement that would implicate Claudio Tihanki Jr. Funny enough, this boss, this employer of Cadenas, was also not presented by the defense in court, and this again was hearsay evidence. Upon re questioning Cadenas during the trial, he vehemently denied that he was tortured at all. Now, you might think, sure, the defense was trying hard to poke holes into the prosecution's case, but there was nothing solid here yet. Well, the defense had something that I would consider quite substantial, at least initially. They called upon the forensic officer who tested the paraffin wax cast that was made of Tihanki's hands. The forensic officer stated in court that she found no gunpowder residue. Now, this was damning for the prosecution. The forensic officer explained that Tihanki was tested around 72 hours after the shooting, and that this was still in the time frame in which gunpowder residue would and should still be found despite ordinary hand washing. I know you might want to know how the prosecution countered this evidence. The prosecution presented their own forensic expert from the NBI, who testified that within 72 hours of shooting a gun, frequent sweating and hand washing, including showering or bathing, would have removed any gunpowder residue from the hands. Washing hands with vinegar is also another way to erase all traces of gunpowder, but the expert was not sure if Tihanki used this trick to get rid of any residue. However, I do think it was implied in that testimony that Tihanki certainly had enough time to get rid of any gunpowder residue because, after all, he was tested 72 hours after the shooting. Now, talk about casting reasonable doubt on a reasonable doubt. The prosecution did good work here. The defense also presented several journalists and newspaper clippings, and I was not too sure what they were trying to achieve with this when I was reading the Supreme Court document. According to the defense, the journalists and their penned articles showed that there was a concerted effort by the NBI investigators to only focus on Tihanki and no one else. That the initial investigation yielded different information about the plate number and color of the car involved. That only after the NBI took over the investigation did the description of the car change from kind of white to silver, therefore implicating Tihanki. I feel like this was a red herring argument by the defense. From the information we already have, we know that there were two witnesses who described the car's color. One said that it was sort of white, and one said that it was metallic gray. Both cars were investigated, and by process of elimination, the NBI landed upon Tihanki as a suspect. I get what the defense was saying as to the NBI maybe developing tunnel vision, but there is a fine line between having tunnel vision and knowing that you are on the right path of following up on a lead, since one piece of evidence seems to lead to another, like a treasure map. The journalists were some of the last witnesses called by the defense. Some procedural matters were settled afterwards, and by then, the trial that lasted for more than a year finally came to an end. The trial court, through Judge Job Madayag, handed down its verdict on the 22nd of December 1992. Claudio Tehanque Jr. was found guilty of all charges and was sentenced to two life sentences and an indeterminate prison sentence with at least 8 years to serve. Tehanque Jr. was also ordered to pay damages. As with almost all the cases that we have covered here at Lagim, and with Tehanque being able to afford lawyers, he naturally appealed this decision. Tehanque was not successful in his appeal, that much I can tell you, but it looked like the Supreme Court had amended his sentence to his advantage. The Supreme Court on the 6th of October 1995 affirmed the trial court's decision, but essentially said that Tihanki did not have to serve more than 40 years in prison due to the provisions of the revised penal code. Originally, as I understand it, Tihanki would have served at least 68 years because one life sentence is equivalent to 30 years, and with two life sentences and another 8 years on top of those, he would have likely had to spend the rest of his life in prison. Also, bear in mind that Tihanki already sat in prison before the trial, and those few months were considered as time served. They would be subtracted from his total sentence. Lastly, the Supreme Court also affirmed that damages would have to be paid to the three families of the victims. As I understand it, the order to pay damages was a separate matter from another civil matter settlement that eventually was agreed between the Tihankis and the Hultmans only. It is my understanding that the settlement, amongst other things, ensured that the Hultmans legal fees were to be shouldered by Tihanki. So, this civil settlement that I just mentioned was agreed and signed in 1999. It was then approved by the courts in 2000. As a matter of formality, the lower court assigned to the civil matter made an entry of judgment on the 17th of February 2000. And on the 13th of January 2003, the Holtmans filed a so called Notice of Satisfaction of Judgment. Such a notice, if I'm not mistaken, merely signals to the parties and the courts that a full payment of the settlement has been made as agreed by everyone. Now, you would think the story ends there, but for those who had been following this case since the 90s, you know that this story was far from over when the new millennium came. Tihanki, seemingly still hopeful to get out sooner than his sentence dictated, filed a petition for presidential clemency in December 2003 when Gloria Macapagal Arroyo was already president. Formal notices of Tihanki's application were published in the newspapers, so all parties concerned could be notified. This took place from the 28th of January till the 2nd of February 2004, and no oppositions were filed. Now, just another sidebar here, and I know I've got a couple already. A presidential clemency is a political decision, so no ratification from the Senate or the Congress is needed. In the past, Filipino presidents had used this power to grant clemency to the poorest and most disadvantaged members of society who had no way or means to fight their case, or who may have been sentenced so severely and disproportionately and sometimes wrongly. Cara David, in her show Case Unclosed, featured experts on the subject and even a descendant of Commonwealth President Manuel L. Quezon, who talked about the origins of this presidential power and how his ancestor used it when he was president. These experts stated that former Filipino presidents were always very careful about their power to grant clemency because they know that granting one could cause a severe media backlash or even a public outcry. A presidential clemency was not granted easily and certainly not without thought back then. But in recent times, or at least since Marcos's presidency, the clemency power has been used to free the more privileged members of society who are or who were well connected to the government or president in some way or form. And this was not any different in Tihanki's case. So, by September 2008, Claudio Tihanki Jr., along with other prisoners, were granted their freedom by virtue of a presidential order of commutation. A commutation is one way of granting clemency, as I understand it. The commutation in Tihanki's case was also further justified with laws that essentially provided for the shortening of a criminal sentence if the convicted prisoner remained of good behavior during his sentence. A lot of people were not happy with the president's decision. It was felt that a lot of mental gymnastics had to be done in order to justify Tihanki's release from his sentence, especially because the Tihankis were and probably still are close to the president's family. In any case, the Holtmans protested Arroyo's decision to grant Tihanki his freedom. They also protested the fact that they were not notified of Tihanki's application for clemency and the commutation that was granted later on. The Department of Justice, or DOJ, then retorted that the notification process of Tihanki's clemency application was duly followed in 2004, and also that the Hultmans did not file any opposition. The DOJ also maintained that on top of the usual notification processes, the Holtmans were separately notified about the clemency application. However, the Holtmans deny this. Furthermore, as part of the signed civil settlement between the Tihankis and the Holtmans apparently agreed that they would not oppose any application for pardon or parole or any other legal relief that Tihanki might make under Philippine law. Justice Secretary Raul Gonzalez, therefore, was noted to have called the Holtmans hypocrites for belatedly protesting the clemency application and also the presidential order for commutation. For the Tihankis, the protest from the Holtmans apparently came as a surprise. They were under the impression that the Holtmans understood what they had signed in the settlement and that they would be okay with a clemency application from a moral point of view. They somehow believed that since Tihanki had asked for the Holtmans' forgiveness years ago and could therefore make amends with them, the Holtmans would not feel negatively about Tihanki applying for any or all reliefs open to him as a convicted prisoner. I'm not sure this apology matters or mattered to a family who lost a beloved daughter, but I bet it made Claudio feel good because despite his denials during the trial, he did finally admit killing Ronald and Maureen and also hurting Jesse. And this is where I have a big problem. This whole situation seems to not take into consideration the other two victims. What of the Chapmans and of Jesse? Have they been consulted? Have they received an apology from Claudio? Have they settled with the Tihankis in a civil matter in which they could receive money for the legal fees that they had incurred? Have they been notified properly of the clemency application? Were they separately told that a presidential order for commutation would be released? From the looks of it, I don't think they have been considered and included in all these processes at all. And I think that is deeply unethical. A few days after Claudio Tihanki Jr. was released from prison, the legal team for Maureen, Ronald, and Jussie filed an appeal with the Supreme Court to nullify the order that granted Tihanki his freedom. The core argument in this application was an alleged violation of the amended guidelines for recommending executive clemency, but also Tihanki's failure to pay damages to the families of his victims. The amount of the damages that he allegedly failed to pay was about $6.2 million, which was essentially the majority of the ordered damages by the trial court. When information and details about the family's application to the Supreme Court became public, the Department of Justice, or DOJ, could not help but also comment in the media about what they thought of the family's application. They said that the family's appeal was useless, as they could not possibly rearrest and detain Tihanki again. According to the DOJ, the commutation could not be reversed. After all, Tihanki's commutation had already taken effect and he was out there living like a normal citizen. As of the time of this recording, the appeal by the three families had been docketed by the Supreme Court, who required any members of the public, including and especially Claudio Tihanki Jr., to file a comment, also known as a response to the appeal being made. I could not find any indication that the appeal was ever heard by the justices, or perhaps refused. There is no online trail about what decision has been made or not made and when. I have tried every possible word combination on Google to find out, and I am currently still in the process of going through 13 years worth of Supreme Court decisions. If I find something, I will make sure to let you know. If the appeal is still in the Supreme Court's backlog, however, then I fear that they will probably refuse to hear it altogether. Again, if I find something that will give us some sort of indication as to the status of the appeal, I will let you know. Now, as for the people whose lives were shaken by this case, their names have faded into obscurity as far as the internet is concerned. I could not find definitive information about Claudio Tihanki Jr.'s whereabouts or whether he was still alive. If he is, he should be well into his 70s or 80s now. The Holtmans moved back to Sweden after Tihanki was convicted, as far as I know, and it can be presumed that Ronald Chapman's family, as well as Jussie, had also moved on with their lives either in the Philippines or abroad. Now, before I end this rather long episode, I would be remiss to not share some more thoughts about this case. I spoke of privilege and hinted at the problem of classism in our society in the Philippines in the context of this case. Despite my initial praise for the NBI and their swift efforts to investigate and solve the case, one can also see the flow of this case from a very different perspective. Bear with me. I promise this will all make sense, or at least I hope so. I found myself asking if the police authorities involved would have acted as quickly and diligently if the murders that took place happened in a poorer part of the Philippines. What if it had been some double murder in a back alley in a smaller town or a squatter area? Would the leads have been followed up so effectively? When it comes to Claudio Tihanki Jr. and his treatment by the police and also the prison guards, do you really think a poor, no name individual who may have committed a lesser crime would have been treated the same or perhaps better? I think not. The Hultman-Chapman case shines a rather harsh light on the issue of privilege and class in the Philippines. What I had not mentioned yet when I was talking about the investigation was that the PNP had actually butted heads with the NBI, who we now know had their eyes set on Tihanki as their main and only suspect. For some reason, the Criminal Investigation Service of the PNP or Philippine National Police and also the Municipal Police Department of the Makati Financial District insisted that Tihanki was not the shooter. They therefore felt okay to release him after he had been questioned only once. There was a dispute between the NBI and the PNP, and it makes me wonder why the PNP was so passionate about absolving Tihanki of all wrongdoings and telling the NBI that they all got it wrong. The dispute was eventually resolved, but it makes you think twice about where the priorities and loyalties are of those public servants meant to serve and protect us. Here's another example. When Tihanki was complaining about feeling sleepless and constipated in prison one night, he was given permission to check into a plush Makati hospital. He was also escorted by the mayor of Makati, and then he took a room just 2 floors above the one where Maureen was fighting for her life. Do you think that the poor kid who works 3 jobs and goes to school full time would be afforded the same perks if he got locked up for even a minor offense? Highly unlikely. Here's my last take. The Hultman-Chapman case took place around the same time as the Visconde massacre, and yet the differences in the way the police investigation and forensic examination were conducted cannot be overemphasized. Whilst the Visconde trial and appeal took around 15 years, the trial for the Holtman case took 15 months, with the Supreme Court decision being handed down by 1995, only 4 years after the crimes were committed. Never have I seen a case so swiftly dealt with before. Sure, the Visconde case involved the son of a prominent family as well, but clearly not prominent enough for the accused man to be treated like Claudio was treated. Furthermore, the victims were from a normal middle class Filipino family with no special claim to fame or wealth or any big name connection at all. In the Hultman-Chapman case, we have 3 victims who were living in upscale neighborhoods. One was a diplomat's child, the other was a bank executive, and the other was a mestiza from a seemingly well to do family. Whilst their privilege was not their fault, we have seen more than once how the status of the victims can equally influence how serious the police would be dealing with the case. We have seen killings, rapes, assaults in poorer parts of the country where we do not even hear about the police investigation anymore. Case in point, the Jang Lucero case I have featured in season 1. Needless to say that this is a bitter and yet normal reality in our country. I can only hope that with greater awareness, each generation of Filipinos will demand more from the public servants who are being paid by the people's tax money. To end this episode, I just want to say that my heartfelt sympathies go out to the Hultmans and Chapmans and to Jussie as well. They all thought that justice was served, but then they had to bear witness to the undoing of this justice. And I can only imagine the long lasting pain that they will be feeling for the rest of their lives. Lagim fam, thank you again for listening to this week's episode. Thanks for all the good feedback from the last episode. I took them all into consideration. And I am also happy to hear that you find long episodes as compelling as I do. Now, I did tell you to stay until the very end, and that is because I have a little case update about the Mark Welson Chua story that I have covered at the beginning of season 2. After I had published Mark's episode, I received a lot of lovely feedback and comments from people who knew Mark and also from his relatives. A cousin of mine is actually friends with one of his cousins, which was an oddly positive thing to learn about. I suppose that it was through these relatives that word about the episode reached Mark's mom, Amelita Magno. She reached out to me by sending me a message on Instagram. She was very lovely and thanked me for raising awareness about Mark's case. She did correct me on one thing I had said in the episode. In the episode about Mark, I mentioned that Mark's late father, when he was still alive, had asked one of the convicted men in his son's case, Eduardo Tabrilla, to tell him the whole story about how Mark died. I mentioned that Tabrilla obliged and wrote a long letter to Mark's father. I assumed in the episode that perhaps Miss Magno had this letter but did not feel quite ready yet to reveal its contents. But Miss Magno said that she does not know where this letter is. She said that if she had it or when she finds it, she would not hesitate and turn it over to the police, who can use it to perhaps apprehend the other men who are still at large. I thanked her for the correction and told her that I will be telling the listeners about this in a separate episode. There's nothing new in Mark's case, and so the outcome that was mentioned in the episode remains the same as of this recording. Lagim fam, before I completely end this episode today, I have one big request. Please make sure to leave a rating, a 5-star rating, and a review for Lagim on Apple Podcasts. Check the link in our Instagram bio for this. Your ratings and reviews help get this podcast become more visible to other true crime fans, especially those in the Philippines. Also, make sure to follow us on all our social media accounts such as Instagram, Twitter, and Facebook. I know I have not paid much attention to my TikTok for a while, but I will be creating some new content for that account soon. So make sure to follow us on TikTok at LagimPod. Lagim fam, thank you so much again for listening to this episode. And as always, I want to thank you for your support. And especially, I want to thank you for the birthday wishes from last week. I read all the lovely comments and DMs, both on the Lagim Instagram account and no, my personal account. Sorry, I was going to say something else. But yeah, I am very, very grateful for all the love, for all the thoughts, and for all the support that you've given in this past year. Lagim is approaching its first anniversary soon, come December, and I am very excited to be planning something special for you. If you have any suggestions, if you have any cases in mind that you definitely want me to cover for the anniversary or before this year is over, make sure to DM me or to put it in the Google document that I have prepared. The link to that Google document is in our Instagram bio. There are several case suggestions there already, and I am trying to work through them for this season. And if I cannot do that, then I'll make sure to put all those cases in season 3. And yes, we will have a season 3. Lagim fam, I'll leave you here now. Thank you so much for your support. I cannot tell you that enough. Maraming salamat at mabuhay.